and good afternoon. We are happy to have you joining us today for our now 11th in our series on the 11 Commandments of Asset Protection. So we've been doing this for a little over a year, almost every month, with only 1 month break. And this particular topic that we're going to talk about, it does cover ethics credits for the attorneys out there. So that's a plus, as we always need the ethics. And it's actually kind of a fun one. You know, people sometimes dread attending ethics seminars because they tend to be dry and not quite as entertaining. But we have some colorful topics to talk about today. And so without further ado, I'll introduce, for everybody who does not know my voice, I am Eric Boughman of the law firm of Forster, Boughman, Lefkowitz & Lowe, and I'm joined by my partner, Gary Forster. Gary, can you say hi to the audience?
Hello, welcome. I think this is going to be a good one today.
All right, and so we've covered different areas, and what we've tried to do through the 11th Commandments of Asset Protection is to basically cover topics that run the gamut of asset protection and through different examples and I would say
it's a menagerie. The problem with the ethics, and the fun part of the ethics, is the different states regulate the ethics side differently from a lawyer perspective. There's also an accountant side, which we'll hit a couple of the cases, but it's kind of a menagerie of law. And unlike the black letter type law, like fraudulent transfer law, the judges, they tend to do what they think is right. So the general theme is going to be, you should also do what you probably think is a judge is going to think is right. I think there's no real clarity in a lot of the ethics side of asset protection, but I think the courts pretty much stick with the idea that prior planning before clouds form is generally going to be all right. You don't want to be taking assets from someone who's running away from a creditor, especially not a government type creditor. That's why we say don't ask others to join the party here in the title. And you definitely don't want to be the professional who's really trying to move assets around in an effort to avoid a creditor. Now, the law is pretty interesting on that.
And okay, I'm sorry to interrupt, Gary. I just didn't want to get too far off track. I just want to make sure we give everybody the agenda, a little bit of background, because we've gotten a couple questions already. I was a little held up because as we started, I like to make sure that everybody can hear us, and a couple questions popped up, but some people asked about some issues, and we encourage that. We like to have the questions come in. I just want to make sure we have our visual and audio, so it seems everybody can hear us from what I can tell, and everybody can see my screen. I've also dropped some materials in the in the box for the GoToWebinar, and so you'll find in there our written outline that covers all of the cases and things that we'll talk about today, and also a copy of the slides as a convenience for everybody. And we're also recording this.
And you'll keep everyone on track.
And we'll keep on track. So so back to our
to go off the ranch. Eric will get you back.
And that was what we did with our 11 commandments. So I started to talk about that. It was we wanted through some catchy titles and fun different commandment examples and titles. We've tried to cover a lot of areas of asset protection, and this kind of culminates in this ethics and morality and professionalism. Some of the questions that we get is, is it right to do, and can the professionals get in trouble? What are the limits of asset protection? And so that leads us into today, where we talk about Commandment 11, don't invite others to the party, and other issues involving ethics. And so this is some of the subject matter that we'll hit on is our issues of morality, legality, whether what is legal and where can people get in trouble. And what we're really trying to do here, look at where we're talking about how to protect yourself, is we want to advise you. hold our firm out as a resource to other professionals, to lawyers and those accountants and financial industry professionals, those who may have questions about some of the things that we deal with. We always welcome your calls and those questions and try to provide ourselves to be available to you as a resource. And here, this is particularly important in this seminar because we're going to cover some issues that we hope will keep you out of trouble, and at least alert you to potential trouble when it may happen. And we're going to cover some examples where lawyers have been sued, people have gone to jail. There's a colorful example with an accountant who spent 10 or was sentenced to 10 years in prison, and bankers have been sued. And so we're going to try and tell you what the warning signs are for that. So, and now we're back on track. It looks like everybody can hear us. Somebody asked about some talking about distinctions in different LLCs. We probably won't talk about asset protection strategy today, and as far as designing a plan. We have covered that in prior webinars. We've done an entire webinar on LLCs.
Well, we'll have some probably time at the end, and if we have time, we can obviously go off outside the ethics realm, but probably most of the people logging in really want a good little foundation in the ethics of LLCs. And as we go through, we can kind of hit on, why we would use an LLC or a trust. But this one's on ethics.
And yeah, we'll do the ethics, but we've done full seminars. We record most of these, and they're available as other written materials.
And we're totally available, by the way. Other than this, we're totally available. You can call us anytime on any kind of asset protection question.
All right. So introduction. So here you go, Gary. Take it away. Tell us what asset protection, what it is, and some misconceptions, what it's not.
Yeah. So the idea of asset protection is it's a law that has amalgamated itself. It's not something that's taught in law school. It's basically a means of structuring what you have in a way, sometimes losing control of, in some ways, sometimes not losing any control of the asset, such that if you get into a dispute or a creditor claim, you retain the asset, or you retain the benefit of the asset. It's something like insurance for a rainy day. And what you're going to see on the ethics side, why it's so relevant, the actual purpose of asset protection, is that when you get away from that, when you start to get into moving things as a reaction to a creditor or as part of litigation, that's when the ethics stuff comes up. It doesn't really come up. I mean, there's some wild exceptions in that country called California, where someone's questioned based upon actual planning, where you actually don't have any claims and you're planning, but that's very uncommon. The planning, the asset protection planning, and the law around it is really generally a very good idea.
And so this we did a seminar a couple of years ago, and we touched on some of these issues. And this one that jumped out is this CPA from up in the New York, New Jersey area, Gato. He was the CPA to Jordan Belfort, otherwise known as the Wolf of Wall Street, and he was also a CPA to a fellow named Robert Brennan, who ran First Jersey Securities, which was a penny stock firm that was said to have bilked clients out of about $75 million through a fraudulent penny stock scheme. And Brennan, for instance, he transferred assets to trusts offshore, and then Gato was the trustee. Gato actually set all this up, so he was the CPA, potentially actually acting in the unauthorized practice of law, and created trusts apparently, and was serving as trustee for Brennan, and did the same thing, was moving assets around for Belfort. And finally, when everything came crashing down around those folks, Belfort testified against Gato, got him in trouble. He ended up losing license privileges.
You cut a deal.
And then, ironically, or maybe not so much, Gato ended up testifying later against another client to apparently reduce a prison sentence to a 10-year sentence. So whatever he was doing, creating these offshore entities to hide assets when the federal government was chasing his clients, that is not asset protection. that's just flat out fraud. I mean, once the clouds have formed and the claims are coming in and the government has sent your client a letter, that's when you want to proceed very, very carefully. Another one we mentioned up here, there's a little more in the written outline about this, but this asset protection group, this was some folks, they were actually selling packages so that anybody, you could be an asset protection
lawyer.
Yeah, you could be your own asset protection professional. It was like they were selling, it was like a business opportunity, which, you know, ought to give pause right there. And if that doesn't give you pause initially, you know, attorneys practice for years and years, and Gary's been doing this stuff for, you know, practicing for 20 some odd years. He doesn't look like it, but he has. And
I look like
and we talk through these issues all the time, and there's still things that come up that we're not aware of. And so when you think somebody's going to buy a package for $10,000 and sell asset protection, but you know what's interesting is that group, it was the disbarred lawyer William Reed and another guy who was a convicted felon, and they were joined by another CPA selling these products, and eventually they got themselves in trouble.
For some reason, there is a part of society that, like, we get this sometimes where we try to create a plan for someone, or they'll send someone to us who's already in trouble, and we'll try to explain to them, you know, that's not the way asset protection works. But they're under the impression that I'm just going to give my, you know, house to my cousin, or I'm going to move to another state or something like that. I'm not sure why that mentality is accepted by certain clients or these criminals type thing, but it's just a terrible idea. It's a terrible idea. We'll talk about the edges of this today. You know, what, you know, at one time actually may have been totally legal and not unethical. You know, some of that, you know, to some extent is changing, and I would tell you without a doubt, the changes almost every time are to the more strict. They're not gonna, the change is very uncommon that liberalization comes on these fraudulent transfer stuff on the ethics and criminal side. The courts get more and more strict. It's going to get harder and harder really for these people to deal with transferring, you know, with the intent to avoid a creditor.
And some examples of some things that can happen to you, we list up here on the slide, and there's cases where professionals have been suspended, in some more extreme cases, lost their license, sued for malpractice for cases gone awry. There was one case we'll talk about where the attorney-client privilege was lost, which could create issues, civil liability, punitive damages, criminal punishment in some circumstances. So it can get serious if you start trying to dabble with a client and keep them out of trouble when it's too late to do so. So let's talk a little bit about morality. I always like this question because this is something that came up a lot when the last downturn in the economy, when the people were not paying bills, particularly mortgages, and there was this question of whether there was a moral obligation to pay your mortgage. I like that question, and that's a personal question. I mean, people, you know, there's two sides to that coin, but I like this quote here. There's this fellow who says, you know, what about, he was interviewed, it was on 2020 or some show, and the president of the Mortgage Bankers Association was interviewed about people walking away from their mortgages, and he says, what's the message they'll send to their family, kids, and their friends, you know, these debtors? And ironically, the Mortgage Bankers Association of America, shortly after that interview, actually walked away from its own building and its headquarters building in Washington, D.C. on a short sale. They had a $79 million mortgage loan out on it, and it ended up selling for $41 million. So even the MBA wasn't immune to their own judgment. We cite some other examples up here. Morgan Stanley did a walk away on some non-recourse real estate debt in San Francisco during the downturn. Mark Rich, it goes back to the Clinton era. He was pardoned. He was a tax evader that reputedly had upwards of $1 billion and was pardoned by Bill Clinton on the last day of his term. And of course, you know, Donald Trump's multiple bankruptcies have been in the news. So, you know, is there an obligation to pay your debts? Do you have a moral obligation? I think that, you know, the way the law is set up, there's rights and remedies for breaches of contract and for debt obligations.
That's not a morality question.
That's not a morality question. That's a legal question. That's a contract question. You can have recourse debt, non-recourse debt. But this is whether to engage in asset protection. What it does is it gives you some leverage. And so we already have we have a public policy. We allow people to file for bankruptcy and don't send them to debtor's prison. And if they come clean, they can get a fresh start. That encourages business development and encourages people to take risk to advance society. We have statutory exemptions here in Florida. We have the homestead exemption. Even if you don't pay any bills, we protect your retirement accounts. We don't want poor people losing everything.
But you have to be reasonable. You have to approach it with detail and intention. For instance, we've never had a plan breached. Okay. But we have we get odd questions sometimes, like, if someone set up my asset protection plan, is it perfect? And we try to explain to people, this law is changing all the time. It's likely going to create substantial leverage for you if you have a good structure. But if you decide, we had this question come up yesterday, that's why it's in the top of my head. If you decide to get aggressive in your business, as people are in business, and violate a federal statute, criminal or civil statute, do I know if your asset protection plan is going to get upheld? I don't know. As you see and you work through these cases on the ethics side, really the courts are much more interested in breaching plans and reaching assets that otherwise wouldn't be available if the defendant is a bad actor. They've done something wrong, they've swindled someone, they've done some kind of a crime, they've run away in the face of terrible hardship that they've caused. And that's the law we have to deal with. So even though that may not fit, those circumstances typically don't fit the client. You have to realize that once there's an issue and someone may be harmed, the judge is going to want to enforce the judgment and reach those assets. So you want to stay away from those controversial situations, or let Eric Boughman defend them in litigation, because there's no more planning that's going to go on.
Yeah, and what Gary talks about here is really a lot of it's, timing is always an issue, and context is an issue, because nobody questions generally whether there's a moral component to establishing a trust, and we use trusts all the time in asset protection. But there's a case that we've talked about before, this California case, where someone had trusts that were set up and told the court, Kilker case, where he said, the trusts were set up for asset protection. I've got no assets in my own name. And he runs into problems because we think, reading from the opinion, we think that he runs into problems because in part context. Had he done the same thing in connection with some estate planning and trying to set things up for his kids and family, and been contrite in his testimony, perhaps he would have run into no problems. But when you are brazen and when you're a crook, frankly, we see a lot of cases where
they really had no claim against Kilker's assets. I mean, the statute of limitations had run. He planned at a time when he could not expect someone to sue him. But he was cocky in court, and the court wanted his assets, and they tried to make his intention to do asset protection a means to reach his assets, which is ridiculous, really. It's the law. That case is now going to be cited anytime anyone does asset protection, I think.
Yes, and that case, the case we're referring to is Kilker v. Stillman. That's in our written material, so you can find a site for that. It's a short case. I'd encourage people to read it just for the context. Summing up the morality question, I think this kind of statement really covers it here. Just because you do asset protection, look, if you commit a wrong and you feel a moral obligation to pay financially for that wrong, the fact that you've engaged in some asset protection doesn't mean that you can't dip into your own assets and pay. But what it does do is it allows you to make that choice rather than allowing a plaintiff's attorney or a a potentially malingering plaintiff to make that choice. So legality. We start with the U.S. Supreme Court that says that prior to a judgment, you can transfer assets freely. So no issue if you're sued, you can sell assets, you can move them, you can gift them. Just be aware that if you are doing so and you become subject to a claim, that can be unwound through fraudulent transfer and other mechanisms. Now, if you try to do these things and become subject to a judgment and then try to hide them or try to defend them, or if you do them with what the court calls a fraudulent intent to evade creditors, then you run into problems. But asset protection is, in general, there's nothing illegal or nothing's going to get you in trouble with structuring your assets in a way to protect yourself when the skies are clear. And so these are some of the common problems that we see. And Gary, chime in here anytime, but really
like
bankruptcy and government.
Is a huge one. We very rarely would counsel a client to go into bankruptcy now because of the really extended authority of the bankruptcy court, where a lot of the statutory and entity type protections are really pretty clear in state law and some of the federal law. You know, in bankruptcy, when that debt is discharged and those assets become available, the really bad cases have stemmed from bankruptcy, where the court just decides to start taking assets that may be otherwise exempt because it's not happy with the debtor. So we rarely would counsel someone to go into that scenario.
And something to be aware of, in all these issues that we've cited here, bankruptcy, there is a portion of the bankruptcy code that provides for up to 5 years in prison for concealing assets or receiving assets fraudulently. We've seen cases with attorneys, for instance, who put the debtor's assets in their trust account with no real intention to apply that to any fees. They're just trying to use their trust account to hide it. That's terrible.
Yeah, and one of the big fraudulent transfer cases involving jail time. The longest jail time was a 6-year jail time. This guy Lawrence, he got into all kinds of problems with his securities work. He took a huge margin account and went bankrupt, and then it subsequently transferred assets offshore. The bankruptcy court kept him in jail for 6 years. I don't know of another case even anywhere near that, but especially in a state court with a non-government plaintiff. Have you ever heard of anything like that?
No, there was a divorce. The guy who spent the most amount of time in jail, but it wasn't an asset protector. It wasn't a fraudulent transfer issue. It was a divorce. He wouldn't come clean with his assets, and he was a lawyer. I think the judge wanted to keep him, but he had total control. And that's the issue with jail. Oftentimes on some of these contempt cases is, depending on the level of, if the debtor self-creates, or if you help create the situation that puts you in jail and you hold the keys to your own cell, courts will keep you there.
Yeah.
But be aware that there's cases like the Gato, and there's other cases where the professionals have gotten themselves in trouble. And there's an old case involving federal, fraud on the United States. That's barred by statute. There's also the Omnibus Crime Control Act, which makes it a crime to conceal or hinder government agencies, conceal assets or hinder government agencies from collection of monies owed. And there's an old case, it's US v. Switzer. We put this in the written materials, where the defendants were convicted under a statute for fraud on the U.S. Based on fraudulent transfers to deplete corporate assets prior to bankruptcy.
Yeah, and very, very careful with fraudulent transfers with a government creditor, because you slip from a remedial claim in civil court to potential crime, just like that, just because it's a different plaintiff.
And of course, money laundering, trying to move assets to hide criminal or other activities to hide the basis from which the money was obtained, to avoid taxes. Taxes are always a problem. If we meet with somebody and the IRS has begun pursuit, we're not touching that. The IRS, the government, we have the whole other seminar we've done on.
Well, we'll
super
handle
creditors.
we'll handle the litigation, but there's no more asset protection.
That's what as far as the asset protection, we'll deal with the IRS, and sometimes there's arguments that can be made, but you're not doing any planning at that point. You're reacting and trying to hide money from the IRS is just a loser. And then, of course, we've talked about fraudulent transfers. And what we're talking about there is reaction. And there are several exceptions, though. And so we go through those. We'll do an analysis. If we have a client who owes money to somebody, to a creditor, even if it's a government creditor, we have a case with involving the FTC, and we've dealt with those issues. There are some things that are protected. There are sometimes some gray areas where transfers were made and there's legitimate reasons for the transfers. And understand it on the other side, if the government or a private plaintiff, if they're coming after you, they're going to come after everything. And there may be circumstances where you actually have some legitimate planning that's been done and you need to defend that, or you have some legitimate exemptions or exceptions and you need to bring those forward and make your argument. So we don't encourage people to just roll over. But what we do say is proceed carefully, and it really requires a lot of analysis before you make a move. That's always our first answer to clients that are in trouble is, should I do this? Don't do anything. Stop for a second. Let's look at the big picture, do an analysis, and then make a plan for what what we can do and what's going to be defensible. And we touched on this a little bit earlier. We'll talk about a few of the cases, but it's the fraudulent transfers. That's what creates the problems. So you hear it over and over, and there's everything from professional to civil liability. Again, punitive damages, and the claims. We'll talk in a few minutes about some of the different claims that are made as far as in the fraudulent transfer context. We've got for professional liability, there's a Minnesota case, and I think there was a civil case was brought against a lawyer in a law firm there, and we've cited this in the materials, where somebody sued the law firm for aiding and abetting fraudulent transfers, and it was a violation they alleged under the Minnesota Uniform Fraudulent and Deceptive Trade Practices Act. We have a similar act here in Florida. Other states have similar acts. There's the New Jersey Fraud Act. Florida's got the Uniform Unfair and Deceptive Trade Practices Act. Well, here in Minnesota, they have a similar act, and the law firm and the attorney were sued. I don't know what the results were out of the case. I don't know if it's settled, but I know that the attorney who was involved, one of them at least, also got in trouble with the bar. So not only do you look at getting sued by a plaintiff who may come after you because they say that you're in conspiracy or aiding and abetting a client in a fraudulent transfer, so they come after your assets. Now you've got to deal with professional issues because you've got a bar complaint, or you've got the FTC went after the accountant, some scenario like that, where now you have issues involving your license and your ability to practice as a professional going forward. One big problem that we see with some of the cases that are the most egregious is where the professional is an active participant in the activity.
Yeah, you want to definitely stay away from that.
And so, one example is found in another case we cited in the outline, but I'll give you the overview here. It's Acadia Partners v. Tompkins. Here there's a lawsuit brought against the general counsel for the company and the company's accountant, who is also the CFO. They were both on the board of directors, and a judgment had been entered against the company, and the attorney and the accountant both were accused of conspiring to devise a plan where the company could essentially funnel assets into another business and hide the company's true financial condition, essentially make the company look like it was broke. And they were going to do that by funneling assets somewhere else. They were sued for aiding and abetting a fraudulent transfer and for conspiracy to defraud and for other related claims. And the case ended up settling before trial, but understand from that the direct involvement. You don't want to get involved. And it's easy to say, but you have a client that comes in, okay, I'm not going to get involved with the transaction. But if you're on the board of directors or you're general counsel to a company, and they're running into financial problems, again, tread very, very carefully. We've seen complaints for civil conspiracy and RICO, racketeering, corrupt organizations actions against commodities brokers for participating allegedly in some fraudulent transfers. We have also seen, as I mentioned earlier, we have the aiding and abetting case that was brought against the attorney in Minnesota. We have claims that were made for negligence per se against an attorney, where the claimants in that case had claimed it was that the attorneys involved with advising a client had negligently advised the client to move assets in violation of the law. And that's it's a Kentucky case. We cite in the materials. It's GATX Corp v. Addington. It's a 2012 case in Kentucky. A couple of the more prominent ones that we've dealt with here in Florida, we have Freeman v. First National Bank, and a second case. There was actually two cases that came out near the same time. Bank First v. UBS Payne Weber, and that bank.
I think they're related.
Yeah, they were right around the same time. One was a Supreme Court case, and one was in the 5th District here in near where we are, out of the Daytona Court, Daytona Beach, Florida, that covers our district here in Orlando. And in those cases, in Payne Weber, for instance, it was an attorney who was sued along with the financial advisor, and the Florida court there said there is no accessory liability for conspiracy to commit a fraudulent transfer. And so the attorney in that case was sued, but ended up with a favorable decision out of the Florida court. And in the Freeman case, it was a similar result where the Supreme Court of Florida, or excuse me, that wasn't Supreme Court, that was the 11th Circuit, it was a federal court, said there's no cause of action for aiding and abetting a fraudulent transfer. But when you read the cases, that case, for instance, they were very careful, the court was, to limit the context of its holding to liability under the Florida law. And so it shouldn't be read to cover all of the 11th Circuit, for instance. And again, even with both of those cases, they were maybe 10 or 12 years ago, but we've had legal development since then.
Yeah, we've had significant legal development. So as a little backdrop, what was going on was there was this open issue. We knew we couldn't take assets into a law firm or an accounting firm and move them somewhere else. That's a no-no. And then we got into, can you explain to the client that if you make a fraudulent transfer, there may be a benefit to the client. The creditor's trying to collect. You have a window where you still control the asset. What if you move the asset to Delaware or Cook Islands? And that client would ask, does that function? We don't do any of this time, by the way, because it doesn't work legally. But there's a practical advantage to sometimes doing these fraudulent transfers. We never do it. So the issue was, can the lawyer do it? And so these cases suggest that the lawyer can advise the client to make a fraudulent transfer because, practically speaking, it's likely going to function as a buffer from that creditor. Now, what's happened is that the collection law is a little cumbersome. It's not very effective at times. So people continue to advise and affect these fraudulent transfers somewhat based on these Florida cases, because it says it's okay, you can do it, you can advise on it. Then the law develops, culminating in a Supreme Court case, U.S. Supreme Court, which took a baseball bat to the whole issue. It's a very subtle issue. It has to do with the fact that lawyers cannot advise a client to commit a fraud if that's an ethical issue. And then if they do, the communication becomes also potentially open and not protected by the attorney-client privilege. It's the famous crime fraud exception. And so the Supreme Court says, and Eric can give you more background, but Husky involved the transfer between a variety of companies and a bankruptcy. And you have trouble discharging. There's an exception to your ability to discharge debt if you've kind of avoided the debt, through fraudulent transfer. You're claiming bankruptcy through fraud. Eric can articulate.
There's a fraud exception for bankruptcy. If you go into bankruptcy, you can discharge assets, but you cannot discharge assets that were obtained by fraud. And that ended up being
obtained by fraud.
A Supreme Court case, and that's another one's Husky Electronics v. Ricks.
So the conclusion, which there was a dissent, but not to this issue, was that fraudulent transfer, which is just a remedy to recover assets, is equivalent to fraud.
And that was the basis on which the court ended up making its decision that a fraudulent transfer could serve as a reason to exempt a claim from discharge. So this, so what happens is that, typical situation where a company owes a debt, one of the individuals involved causes the company to move assets to another company. He gets sued personally on a fraudulent transfer claim. He ends up filing bankruptcy, and in the bankruptcy case, the creditor says, hey, you committed a fraud through that fraudulent transfer, and because you committed a fraud, you can't discharge that debt. And it went all the way to the Supreme Court. The Supreme Court, it was 8 justices. It was after Justice Scalia, may he rest in peace, passed away, and before his seat was filled. And the Judge Sotomayor wrote the opinion, and it was a fairly short opinion. It's just a 2016 case. She had no problem at all.
No.
And the court took no issue. It wasn't even a question of whether or not a fraudulent transfer was
they
fraud.
didn't even debate it. I mean, we have all these cases in terms, splitting the issue. Was it fraud? Is it fraud? Is fraud fraudulent transfer? Fraudulent transfer fraud? They just kind of bulldozed. They
got there with no problem. Went through the history. Of course, it's fraud. But the question, they had struggled with another issue. It was a more technical issue, really a bankruptcy question. But this fraud question that the court, and it was only one dissenting justice, was Justice Thomas. And he
didn't dissent to that.
He didn't dissent to that. He took issue with the fact, he said, well, this wasn't a debt obtained by fraud. This was actually just a debt that was the result of the fraudulent conduct. He was sued on the fraud, and that's what created the debt. And Justice Thomas took issue with the particular language in the statute in 548 in the bankruptcy code. But
now that the Supreme Court has said this, is it now unethical everywhere to counsel a client to effect a fraudulent transfer? I've always been afraid of it personally.
Now put it in a Florida backdrop. We've got the Bank First. The argument that was made, and I know the attorney who argued that Bank First case, and he would tell you that that you've got an obligation to defend a client, including make it as difficult as possible for a creditor to collect. So as long as he's not doing anything illegal, you have an obligation as the attorney to put up every possible barrier until the law says that a fraudulent transfer is actual fraud. Then go ahead and commit fraudulent transfers because there's a statutory remedy. I can commit the transfer. This goes back to the question on the contract. Do you have a legal obligation or a moral obligation to pay your mortgage? Well, no, I don't think so, because you have a mortgage document, you have a contract, and if you don't pay, then the company on the other side, your counterparty on the contract, has remedies under the contract.
Well, it's not that you don't have a legal obligation. You do, but you have
nobody's coming
remedies.
to arrest you.
Right,
the other side has remedies. They can foreclose and they can come after your assets. Well, the fraudulent transfer statute in every state provides for certain remedies, and so the statute says if you transfer assets in the face of a claim, these are the rights of the creditor. Within a certain amount of time, I can unwind those assets and I can go sue the transferee and drag them into the suit. But it doesn't talk about fraud. And so the argument from Bank First was a fraudulent transfer is not fraud. It's a statutory remedy with just a weird name. And in fact, in 2014, we get our act, the Fraudulent Transfer Act comes from the Uniform Act. And that Uniform Act is one that is created by the Uniform Laws Commission, and they send it out to the states, and then we say, this is what we think this law should be in every state.
Florida's
common state to state. And Florida adopted the old Uniform Act in substantial part, but people take revisions. There was a new act in 2014, and they actually changed the name to Uniform Voidable Transactions Act. They got rid of fraud in the name, probably because of this confusion.
Unfortunately, they didn't get rid of the word fraud or deception
in the statutory language,
which would have been great. That really would have been the move.
But we have this question here of whether or not a fraudulent transfer is fraud. And the same question came up, right around the time this Husky decision. It was 2016. There was a decision, or maybe it was 2015. There, I've got the case cited in our materials. It was the Cadle decision in Nevada. Nevada took a similar approach, except they said, well, a fraudulent transfer provides for a remedy, and that's just an equitable remedy. You can unwind the transaction. But in Cadle, a law firm was sued, and the court said, you can't. This is the Supreme Court of Nevada it went to. And the Supreme Court of Nevada said, you can't get money from the law firm if they weren't a recipient. All you can do is unwind transactions but go after the recipient to get that money back. But it's an equitable remedy. We put the asset back in the hands of the creditor or debtor so you can take it, but you can't sue the law firm.
And that's what the statute
And Florida says that, and the statute says that. And then you get this bomb from the Supreme Court where they spend a page and a half giving some background on fraudulent transfer, explaining that a fraudulent transfer is your garden variety fraudulent conduct. Now that throws all these other questions.
Now we're just waiting for the new case.
So you got Florida and Nevada and other places who've said a fraudulent transfer is not fraud. You got the Supreme Court saying a fraudulent transfer, the U.S. Supreme Court saying a fraudulent transfer is fraud. And we think that now these in the next couple of years, we're going to see some decisions. We're going to see some attorneys take a shot at going after people here in Florida and in Nevada and other jurisdictions, and they're going to rely on that Husky case. I haven't seen the batch of litigation coming out, but we will. I think that we're going to see some issues with that. Let's touch on, we cite in the materials, there's some criminal cases. I'll tell you that generally the criminal statutes dealing with fraudulent conveyances often involve secured assets. So it's usually where there's a fraudulent conveyance of something that's secured by encumbered by a security interest, like a lien or a mortgage. If you try to fraudulently move the asset to get it out from under that encumbrance, there's some states, I know Arizona is one that has a criminal statute. I think New York is another. In California, I think it depends on the judge.
Yeah, and then of course you have the government claims on the criminal side, which do not require security.
No, the government, IRS, bankruptcy. So what's the professional to do? What client comes in and gives you this, I've been sued, I've got this problem. First of all, if it's a government agency that's coming after them, the warning bell should be going off extra high and extra loud. But any type of claim, things you need to be aware of. First of all, doing anything if you're not an attorney, like what Gato's creating trusts, and you got to be careful just doing that outside your own jurisdiction. If you're not an attorney and you're creating entities and creating trust agreements, moving assets around, you could get hit for unauthorized practice of law. You have these multi-jurisdictional issues where somebody contacted me, for instance, from up north, an attorney that I know, and a good litigation attorney, but he had a client who was subject to a judgment in a northern state, and she was going to move some assets to another state up north, and then they were going to create an LLC in that state, and then she was going to move the account down here to Florida. You're bouncing around 3 or 4 different states. When we do work in other states, we generally associate with, we have some local counsel who checks off on this stuff.
And other countries.
And we do international. We do a lot of international work, and so there's somebody that we're working with to ensure, that we're compliant with the local laws. Now you say, well, why not just go to that state or that jurisdiction or country? But oftentimes in asset protection planning, like when Gary's doing planning,
we have established relationships with these groups.
Not only that, but you may be using multiple jurisdictions.
We are.
So
We're using. It's a plan, and you know, someone in Nevada is not. They're just know what their law is, and we make sure that everything's valid, and we do the work. We just want to make sure there hasn't been any weird changes in the law that they would pick up, or Delaware, or even Nevis, West Indies. So we quarterback it, but we do recommend that you create these relationships if you're going to do stuff in other jurisdictions.
So you really need to be careful, and as some of the cases we talk about, you know, emphasize the law isn't the same from the law is not the same from state to state.
This law really varies.
Yeah, the asset protection in general, what's available, what will work, fraudulent transfer laws.
The ethics are different even.
That's right, and the ethical responsibilities for the attorneys. Other issues, you have conflicts of interest. This comes up all the time. You know, somebody comes in and wants you to create an LLC. Well, do you represent the LLC, or if it's a multi-member, do you represent one of the members? Are you representing all of the members? Are they signing a conflict waiver? If you're creating entities, especially if you're not a lawyer, even if you are a lawyer and you're creating entities and you're not dealing with these questions, you know, who do you represent? And to whom do you owe a duty? And if you're a lawyer, by the way, in Florida, and you say, I don't represent anybody, I represent the transaction, you call the Florida bar, they will tell you that that is not permitted. You have to represent the client.
You can't do that.
You can get yourself in trouble. You know, creating trusts, if you're, you know, parent, child, husband, wife come in and they want you to, you know, create a trust instrument, again, who do you represent in the transaction? Yeah, conflict issues come up all the time in creating structures, and they can come up, by the way, in the context of a fraudulent transfer where you're moving assets from one person to another or from one entity to another. You end up dragging somebody into litigation that wouldn't have had to be there, but for the fact that they were a transferee of an asset trying to get somebody out of paying a debt. We have some notes here for the attorneys. For the ethics side, and by the way, this can affect more than just the attorneys, but there's a Connecticut opinion that specifically deals with a fraudulent transfer, an attorney who how the attorney could get in trouble, and that opinion is cited in our materials. The Florida rules and the model rules of professional conduct have rules that potentially deal with, you know, again, generally it's fraudulent transfers. But also the rules dealing, you know, if you're engaging in asset protection planning, you have a duty to, you know, for the attorneys, essentially know what you're doing and be competent and act with reasonable diligence. There's a case that we cite there, Florida Bar v. Klein. This is a case where the attorney was participating in a fraudulent transfer with a corporation that ultimately filed bankruptcy. And he ended up being sanctioned and disbarred for violating the ethical rule that prohibits conduct involving dishonesty. So there's your attorney getting disbarred for being involved in a fraudulent transfer. We want to allow time for questions. If anybody has any questions, feel free to type them into the box. Unfortunately, we can't open up the microphone for everybody. And I want to emphasize again as well that if you have questions afterwards, and you want to call me or call Gary or shoot one of us an email, we're happy to field those questions and take your calls. We also ask if you connect with us on LinkedIn. We'll provide updates on materials on our other seminars and webinars. We'll be doing another one next month. It's a wrap up of what we've done this month. We've got a couple minutes left. You know, some other stuff we may want to cover. You know, another thing I mentioned is it's not just the attorneys. You know, the attorney-client privilege. There's a case in Ray Cutoli that involved really some bad actors that came from California, and there was a claim against this woman, and she got married, and she tried to transfer assets under this prenuptial agreement to the person that she married, and the person she married also happened to sue her in some dummied up lawsuit. And you know, the upshot of it all out of California was a huge judgment against this person from California that included $10 million in punitive damages. She came here to Florida, again, tried to hide assets. They tried to encumber property, her and her husband.
It was a circus, basically.
And they hired an attorney in Florida, and the attorney was an asset protection attorney. That's what they were advertising. And they filed for bankruptcy, which you should be filing for bankruptcy. No. You should be committing criminal activities. You shouldn't be moving assets around fraudulently, which is dummying up liens and lawsuits to avoid claims. And the bankruptcy court here hammered them. And the bankruptcy court breached the attorney-client privilege, which is generally sacrosanct. But here the bankruptcy court said, you've lost the privilege because of the crime fraud exception. Your actions were so bad. Not only did the debtor lose the privilege, but the husband lost.
They had some actual criminal actions beyond even the wasn't the underlying. There was some underlying. They were a disaster.
They were bad actors. That's a long, complicated case. But the takeaway from that is to understand that if it sounds bad, if somebody comes to you and they're talking about, well, we're gonna, we're husband and wife, we just got married, we have this prenuptial agreement, my wife is transferring me all of her assets, and oh, by the way, I'm also going to sue her and record a judgment. That should, you should know that doesn't sound right. Wait a minute, you're suing, and
it sounds like the case they asked us to be a witness.
And I'm actually surprised that, I don't think the attorney in that case was shown to have done anything wrong, but certainly his communications got exposed. So understand, you could be communicating with somebody thinking that there's a privilege. Here in Florida, we have an accountant, a privilege that applies to accountants and their clients for evidentiary privilege, where you can't get that communication in litigation generally. And you can lose all that, and everything you're writing to a client could be exposed. So be aware of that.
He wasn't. He wasn't aware of it. He wasn't. No, he got way over his head.
So, when you're going to engage in some asset protection planning with a client, or when you start talking about it, these are the things you want to look at. Who are the client's creditors? Identify, who the creditors are. What are the debts? Are there any debts that are in default? Is the client having any problems paying creditors? Is the client anticipating having problems paying creditors? Has the client been sued? What are their obligations? Not only as a borrower, but as a contingent obligor, such as a guarantor, or under some other arrangement where they could become subject to a debt. Again, the lawsuit question. And if there is a lawsuit, what stage is it in? Is there a chance that there's going to be a judgment? What are the chances there's going to be a judgment? By the way, just because you're sued and just because you may have a judgment entered against you, we see this, for instance, in the medical arena, where a doctor may be sued on a malpractice claim that looks totally bogus, and the claim value isn't very high. It doesn't mean you can't do anything. What it means is proceed with caution. We've done a whole separate seminar on valuation issues, how to value some of those claims, set aside enough how to value a potential lawsuit or judgment or claim against you, and then set aside those assets and leave them available, leave them exposed. But you don't have to leave yourself exposed to everybody else who is not in the picture. Auditing, obviously IRS issues are huge. Solvency issues, bankruptcy issues. If the client's talking about bankruptcy and trying to do some asset protection planning, those two do not mix. Bankruptcy is for people who have not planned. If you have planned ahead of time and hired somebody like Gary to do your planning,
there are some rare exceptions to that, but yes,
yeah,
some rare exceptions.
Generally, we say that bankruptcy is the fallback for the person who didn't plan. We've got 12:55. We've got a few more minutes. We can take questions. Again, some of the same, similar type analysis here. Looking for a client, at a client to determine if the client is a good candidate for asset protection. Look at those things we just talked about. Look at what the current financial landscape. We have clients in our practice. We have people fill out a questionnaire that walks through all of these issues. We want to know everything that's going on. And again, if there's some, if there's some hair on something, if there's a potential claim and you're not sure how to deal with it, give us a call. Gary does the planning. I do litigation. I look at these issues all the time. We can talk through it. And we just had one recently where we talked through, is this a client that we can represent and that we can help? And, what are the issues going to be? we don't automatically turn something away because there's problems. I mean, people, after all, hire lawyers oftentimes when they have problems, especially litigators.
It's not a planning matter at that point.
But at that point, and it could be, there's things you can do in Florida. We've got the guy, you've got the Havico case, the guy's being sued in Tennessee, runs to Florida, buys a big beach condo, and the O.J. Simpson scenario. You can do that. We can advise clients, if you come here and buy a homestead, it's generally going to be protected from most creditors, although that has been chipped into in the last couple of years as well. Ironically enough, not from the original debtor, but from third parties involved as transferees. So another case we could talk about another day. We'll come back to that one. That was very complicated.
So do we have any questions? No questions?
I don't see, nothing's popped up. Somebody did ask, about cover the distinctions between single and multi-member LLCs. We generally, on that, you want to use a multi-member because there's stronger protections, especially in Florida. Every state is going to have pretty strong protections generally against a multi. Well, the
states differ, but if you're a single member LLC, the trend is to allow for the foreclosure of that interest.
Yeah, let me put it differently. The states, the weakness is going to be, if there's a weakness, it's generally going to be a single member. But there are states that protect
by statute.
Right. So if you
have to be a single member, then you would go to those states. The issue then you'd be protected technically, and the issue then becomes, if I'm in Florida and I go to those states to form my single member LLC and put valuable assets in it, will a Florida court respect it? We have a case that says to a woman who had done a fraudulent transfer that no, they'll consider it to be a Florida LLC. She had an offshore Nevis LLC, and then we have another case in Florida that says, well, that may be, but if the share certificates were issued and they're somewhere else, well, the creditor has to go to wherever they are to go try to collect them. And then we have other cases in Alabama, among others, that say, no, we're going to respect the law of the other jurisdiction, which protects the LLC. That's kind of it in a nutshell.
That covers it. And be aware, if you're dealing with the LLCs, there's some recent cases that have come out where the 99% 1% LLC, that has now been attacked, and we've been waiting for that to happen, where the court says that this 1% interest isn't going to be, basically they allowed reverse piercing of the LLC. And that's a wrap. We talked about Husky. That's the big case we're going to be talking about for the next couple of years. And it's 12:59, and we've got to move on with our day. We're sure you have to as well. Thank you again for joining us.